Good evening, everybody, and welcome down to our third/fourth webinar. Actually, isn't it now, Paul?
It is indeed. Yep.
Yeah. So great to see so many people kind of already logging in. Do send us a message if you are here today. Great to see you all kind of saying good evening and joining us here today. So thank you very much, and it's going to be a quite an exciting evening, I think, isn't it, Paul? Kind of a bit of myth busting, a little bit of an update on the Renters' Rights Bill, obviously, which is the main reason why you are probably all here today, and a little bit of a market update to start off with. But how have you been, Paul, since we last spoke?
Well, this is the notes, the guidance notes for the Renters' Rights Bill. So this has been my Bible, going through this bad boy, trying to make sense out of something that's honest, pretty ridiculous, but yeah.
You've been fairly bored then, Paul, I take it.
It's trying to make sense of it, but we're in a good place. We know where we're at, and I think it's fair to say they're not going to change anything of it apart from a few little tweaks here and there. So the core element of it, we can have a good chat about, which is good.
Absolutely. I'm sorry, guys, if I keep looking slightly this way this evening because I've got my screen is up here where I'm kind of controlling the bits and bobs. So I am paying attention to you guys there, but just so I'm not looking straight at you all the time, so to speak. But so what are we covering today? First of all, we've got obviously a little bit about who we are, myself and Paul. And who we are as a company, and then we're going to do a bit of a brief market update. I'm not going to spend hours and hours on that today because I think that the main reason why everyone is here is for that third point, and we're going to kind of really focus on 6 elements, aren't we, Paul, as to kind of the biggest kind of changes and those elements, and there is going to be plenty of time for some Q&As, question and answers near the end of the webinar. So please do drop those into the chat throughout, and I will move them into the question and answers only. And then if you kind of scroll across, you'll be able to see those questions already asked. So do drop them in when you feel the need to, and we'll get to those kind of after a little bit of a market update. We'll do some. And then also at the end, or if they're relevant, we will get onto them probably as we're kind of whistling through it.
We want this to be very interactive, don't we?
Yeah. The more you guys kind of quiz and question, the better it is for us. We'd love to see all you guys and kind of be able to interact directly with yourself, but obviously this platform doesn't allow that. So first of all, who are we and why are we kind of talking in front of you today? So combined now, actually probably got a little bit more than 35. It's 37 years of sales and lettings experience now, sold in excess of kind of £200 million worth of property, as well as professionally qualified. And this is more recently industry kind of coaches and speakers. In fact, those pictures there were from the 8th of November, wasn't it?
I think so.
This month we actually stood up in front of letting agents around the country and kind of updated them on our business as well as the letting industry. And as you can see, they took a bit away from it, and that was a great experience, wasn't it, Paul?
Yeah, brilliant. Yeah,
really good. And ourselves as a company, that's myself and my father. My granddad actually set up the firm in 1966. Dan's been in and out of the firm for 40 plus years, and as of September this year, he's kind of taken up a bit more of a chairman role, and I'm now kind of taken up the managing director role. So really exciting times as a company into its kind of third generation, or as my grandfather would say, we're probably into our 4th or 5th, because we were builders in Colchester back since 1860s or around that kind of era. So very, very well established. And that's us there. team of us, nice family-run firm, and this is some of the services that we do. Obviously, sales, lettings and management, leasehold estate management, holiday lets, as well as property sourcing, on and off market kind of property sourcing as well, which is a big area of the business that we are growing over the last year and into next year. Some really exciting times as well ahead of us, aren't there, Paul, on that front?
Yeah.
Absolutely. 4 officers at the moment in there, and we are looking to continue to expand and grow. So hopefully over the next year and a half, 2 years, we'll hopefully see a few more spots perhaps, but more on that as and when it happens. So Paul, talk to us a little bit about some of the tenancy health checks that the guys have been doing since the last webinar. I know that's what
we talked a lot, didn't we, in the last webinar about the importance of routine visits, and I think it really hit home with some landlords. We were talking about the model tenants, the model tenant being the tenant you don't hear from, that pays their rent on time, you don't have to do any maintenance, they sort it out. And you generally don't hear from them, and there's this misconception that for a landlord that is the best tenant to have. We did deep dive into that. It's like, well, hang on a second, who's living there? You've got your right to rent, you've got your Section 11, you've got your HHSRS, and it really worried a few people. And we've had a lot of phone calls. We've helped a lot of landlords just to put their house in order a little bit more and get something routine set up so that they can assess. And some of these landlords, they're doing these visits and they're getting the reports and thinking, Christ, what the heck has been going on? Because they've just not been there. We spent certainly since the last webinar, that's really been something we've helped a lot of landlords with at the moment.
I know there was several landlords where they have actually passed it on to ourselves to take over the management, and with our tweaks and with kind of Section 13 increasing rents and those kind of things, we're paying for ourselves as well, aren't we? In many of
that's the key thing. I think a lot of people, you can fall into a habit, can't you? If the tenant's looking after the property, fine, you forget about them, the property looks after itself, it ticks over, and it kind of falls out of your vision, your forethought. But then, when you look at some of the rents they're charged, you nearly fall off your chair and you think, crikey, this rent hasn't been reviewed for like the last 5 years, but I can guarantee the landlord's costs have increased in the last 5 years.
Absolutely.
Yes, it's been quite surprised to some landlords as to how far behind they are with their rental income. And then again, yes, because of that, pointing out there's no cost to them. They've not seen it. They're still making more money, but with the benefit of knowing that a professional agent such as us can look after all the compliance and they don't have to worry.
Absolutely. So do take up the opportunity, guys. If you are watching, you attempted last time to book a tenancy health check. Do that. It's free to anyone that has watched the webinar. It's something that we do for landlords, and it's just a peace of mind, really. So do book in for that. I'll leave that up there for a moment for you guys to have a look at that. And
I think it's worth just adding there, Phil. You get between 15 and half an hour, 15 minutes and half an hour of one of our lettings experts. The value of that is normally about £299. So that's what we're throwing out for free at the moment. So it's well worth people, even if you just dot all the I's and cross all the T's. At that moment in time you're compliant. It's totally free. You might as well just do it.
Yeah, you can sleep at night then, can't you, Paul?
Absolutely, yeah,
absolutely.
So fines.
Right, on to a little bit of a market update. I'll just make ourselves a little bit smaller down there, just so you can see what's been going on. As I say, we're going to kind of fairly swiftly jump through here. So average asking prices over the last quarter since the last webinar have dropped. In fact, you've kind of seen a 0.8% drop since this time last year, and a monthly drop of 1.4%, which is £5,366. So it's not a massive amount on that front, but more specifically for Colchester, which is head office. As you can see from there, overall 339 over the last year. They were, let me move ourselves across. over there, 327 average, 6% down on the previous year and 3% up on 2021. So we are seeing that the actual physical sold prices are down on last year by 6%. So a lot of people out there are still on the market at probably a little bit more than what they probably what they should be, Paul. I think we've found that there's still a lot that are potentially chasing the market a little bit, and it's actually a lot better to come on at a reasonable price, get the interest and get sold, rather than going on an aspirational price and then reducing your property price down. It's actually counterintuitive to do it that way, rather than going on at the right price, getting the demand right, getting people through the door, and actually getting a bit of a feel about it that it is going to disappear. Otherwise, it is a bit of a buyer's market, really, isn't it, Paul?
There's like common misconceptions in there. It's like, well, let's test the market at this inflated price and see what happens. But the risk you run with doing that is, yeah, okay, fine, test the market at that higher price. But what then happens is your property becomes stale during that 2 weeks testing. So then you're forced to reduce it. And unfortunately, when you reduce it, people look at it and go, right, well, why is that reduced so quickly? There's obviously something wrong with it. So you're creating this negative marketing of your property, aren't you?
Mm-hmm. Absolutely. I thought this was, I don't normally add this one in, but a lot of people ask about the average time to secure a buyer. This is number of days nationally here, just thought I'd add. And as you can see from there, we were up to 78 days in early part of this year, January. But it has now leveled back out. But 62 days, some people do come to market and they expect their property to be sold within 2 weeks. But in reality, that is your national average there of 62. So if you're on the market for 40 days, which seems like a long time, a month and a week, in reality, you're doing better than the average. So I felt that was quite a prudent thing to put on there, just as a bit of a realization on that front. Update on the letting side. Again, let's get us out the way there. As you can see, the rates or the rents have continued to grow in terms of quarterly increase 2.3, annual increase 5.2. But the inquiries for each property has dropped slightly, as you can see there. Whilst down from 26 in 2023, it is more than double the 8 in 2019. So I know that speaking to people like at that conference in the early November, they were saying, oh crikey, we are seeing a lot less tenants inquiring. In reality, it's still a lot more than what we were pre-pandemic, isn't it, Paul? It's still very much, if you're getting 15 applicants for each property, you can see there's a discrepancy as to demand and supply there. Absolutely. Anything to add on that front, Paul? Or
no, not really. I mean, it's not. The stats aren't overwhelming. They're indicative of where we are in the season. Nothing to get too excited about this moment in time, I don't feel.
No, I think it's just 26 that was crazy, that was. And then yields, we're kind of at around, in our area, 6%. So if you're working yields out around that 6%, I must admit a lot of investors that we are selling to are looking for higher yields than 6%. A few years ago, if we were getting 4.5 for a nice property, long standing, that was enough to kind of get someone on board. But I think with the likes of the increase in stamp that happened as of the budget and other items associated with it, lending being more, people are looking for over 6%, 6.5 or something in that kind of realm. So that really is that might be the average on that front. And a little bit on mortgage. I'm sure everyone's aware that we've seen mortgage kind of base rate just come down slightly, which is 4.75. The next kind of update on that is next month. So we'll see if that comes down. in terms of these kind of figures, I think I worked out it's about if you're lending 300,000 over a 25-year term, from the 5.25 to the 4.75, you're looking at 25 to 50 quid a month difference. So it's a little bit of difference. It's a little bit of a nice feel factor, but it's not going to kind of set the world alight and flock everyone to start getting mortgages again. But yeah, it wasn't sustainable where we were anyway before, was it, Paul? To be honest, where the mortgage rates were. Absolutely. But if you've got any questions on those, I'm going to pop that. There's a question there, so I'm going to pop that in the questions. Is this price drop national, as I don't have properties in Essex? That was specific to Colchester. That 6% kind of down was specific to the Colchester and surrounding areas. I think nationally it has dropped slightly. Let me I'll check that, and we'll come back to that in a bit.
Ashley's asked a question also about local authorities and their stance when it comes to. So actually, we'll cover that a little bit later when we talk about the bill.
I'll move that into Mark as a question. Super stuff. All right, but yeah, if you've got any questions on the market side, then do let us know on that front. And yeah, the kind of what we've all been coming for really is the Renters' Rights Bill. So we're going to go through kind of the 6 main kind of burning questions that we've been asked repeatedly again and again over the last 2 months. We did touch on some of these on our non-live webinar, which some of you guys may have watched, but we're hoping to go into a little bit more in depth on there. So, Paul, first of all, I suppose abolishment of Section 21s. The Renters' Right Bill aims to immediately ban Section 21 no-fault evictions by next summer, according to Housing Minister Matthew. What does that mean? What does it mean?
Okay, so let's add a bit of context. Let's just go back a little bit and just talk a little bit about the history of the bill, because there was a lot of Renters Reform Bill, and that's now gone on to the Renters' Rights Bill. So the bill was first drafted in its first reading on the 11th of September, and then it was quickly followed up by the second reading on the 9th of October. So they're speeding this through very, very quickly. It went to committee stage on the 22nd of October. Through to the 5th of November. That's obviously now passed. So the third reading and report stage is going to be early next month. And then the process will be repeated again in House of Commons.
There was an update, Paul, wasn't there, in terms of they've got to provide an update as of, weirdly enough, as of today, isn't it? That's right. Yeah. So the results of the report should be at some point today. So I'd imagine tomorrow we should have a little bit more of an update. But as I said earlier, the main content of the bill is unlikely to change. Section 21s will not be coming back. They are most definitely going. Periodic tenancies will be the norm. So we need to basically work with that. In terms of activation dates, we've been told it's going to be spring, summer 2025 with a backstop date of potentially October 2025, but it most definitely is coming. So Section 21s, we all know Section 21s, I don't know why they call them no-fault evictions. They're not evictions, they're a possession notice, which if the tenant doesn't adhere to, then goes to court under accelerated possession proceedings. But somehow the media have got this thing about it's a no-fault eviction. But yes, they are going. And what that basically means is that anytime you want to secure possession, you need to do so under Section 8. So just for those who don't know what that is, Section 8 is an apparatus. It's a document that you use to quote currently one of the 17 different grounds in which you can secure possession under Schedule 2 of the Housing Act. Those number of grounds are going to vastly increase. I think it's up to about 35 now. And you will have to rely on one of those grounds in order to secure possession, which means you have to go to court. So every time you want possession,
you have to go to court to secure that possession, and you have to quote one of those grounds in order to secure that possession. So what's going to happen is the whole process of securing possession is going to be considerably longer. So what they've done, they've broken it down. You've still got your discretionary grounds and you've still got your mandatory grounds, but the notice periods have vastly increased. So basically what they call a non-fault tenant notice, to say, for instance, a landlord wanting to sell a property, that notice period now is 4 months. So if a landlord wants to, we'll get into this a little bit later, but if a landlord wants to serve serve notice to secure possession, it's a 4-month notice, and it can't be served within the first 12 months of that tenancy. So you can imagine the timescales have vastly increased. It's going to make landlords really have to think about the future of their property and what they want to do with it. But yes, Section 21s will be gone.
Absolutely. So, Paul, I must admit, I was busy kind of reading some items there that were flying in on the chat. In terms of, have you mentioned the various grounds in which you can serve notice on those through the Section 8? Have you got to that section?
There are, I think we've got, no, pop slide up. There are, I think it's 30, here we go. There they are, all these bad boys. So there's, I think it's 26 mandatory grounds. There used to be 8.
Out of the way there.
So you can see the difference it is now. There's a lot of those grounds won't be relevant to a lot of people here today. So we're talking about agricultural possession, etc., etc. So you still got ground 8. Ground 8 is the same as it is now, but the difference with that is, rather than currently we serve notice on a tenant who's 2 months rent arrears, we won't be able to serve notice on them until they're 3 months in rent arrears, and that's what we found. The notice periods you'll see in that last column
just been bumped up, haven't they, slightly?
Yeah, they've greatly increased. Which we can't get a head round why you would let a tenant stay in a property for longer when they're in arrears before you can get possession of the property. Now, I did a little just jot some stuff down here to say, right, okay, well, what does that look like in terms of an example? So I looked at the notice periods and how long it takes to get to court, etc., from the experience that we have, and then compared that with what it would look like under the bill. So let's assume the rent's £1,100. That's the average rent at the moment. So we've got £1,100 rent. At the moment, we issue a Section 8 notice on day 32. That's when the tenant's account falls 2 months in rent arrears. So at that stage, the tenant owes $2,200. Okay. The Section 8 currently has a 14-day notice, after which we can request a possession hearing. It takes about 2 months to secure that possession hearing. So by each time when the tenant gets to court, the tenant owes 4 months rent, £4,400. All right. Let's assume we get a 14-day possession and the tenant doesn't leave, so we have to go to bailiff. We can add another 2 months because the bailiffs are incredibly slow at the moment. But basically, we're looking at roughly about 6 months rent, so £6,600 in lost rent and the costs involved. Now, if we compare that to what that looks like under the bill, all right? You sitting down? You ready? Okay, so we can't issue until 3 months. So instantly, the tenant owes the landlord £3,300 before we can do anything. All right. We issue the notice. It's now 4 weeks, so that's another month. So now the tenant owes £4,400, and we've not even got to court. All right. Because the process of securing possession, regardless of the grounds you're using, has to go to court, the already backed up court system is going to be gridlocked. Absolutely gridlocked. So there's not that we know, there's no further investment in the court system.
No provisions, have there, Paul? They haven't looked at kind of putting any more money into it to deal with the extra.
No, they seem to think it's fit for purpose.
Yeah,
they seem to think it's fine and it will cope. I don't know how or where they're getting their stats from, but neither way. So rather than it taking 2 months, I think it's an educated guess that it's going to take, because let's think back to COVID, just after COVID, when we were flocked and we had loads of court cases. It was taking up to 6 months to get a court case. So let's assume it's 6 months. So now £6,600, which is the same as when you secure possession. You get a 14-day notice. The bailiffs are going to take a lot longer. So we worked it out roughly. It's going to be about £13,200 worth of rent, which is just over a year's worth of rent before a landlord can secure possession of a property.
And that Paul is without the tenant playing silly boys or as such
following the court process through
on 3 months and 28 days, putting £1 of rent into the account or something like that to not get into arrears to provide it. It's
a massive concern that tenants are being permitted to have that additional time, which it wouldn't be so much of an issue if the court system was fit for purpose, because, okay, fine, you say, right, we're just adding on another month. But because the court system is fit for purpose, there's that other delay there. And then the bailiffs are going to be run ragged. So then there's another delay there. So all of those delays stacked together, the chances are it could be that if, going back to what Ashley was saying, where local authorities are saying to people, you need to sit tight until you get a bailiff notice, which is what we know is what they tell them at the moment, we could find that it's over a year before a landlord gets possession of a property. Now, if a landlord doesn't have a year's worth of rent stashed, because they still have to maintain the property, they still have to carry out all the relevant maintenance. They can't stop, just because the tenant's breaching their part of the contract, they can't stop doing their part. Otherwise, there'll be things like rent repayment orders, there'll be banning orders, there'll be fines left, right, and centre. So unless the landlord has got that money stashed, and then obviously there's the cost as well, its rent guarantee is going to be vitally important to any landlord who is renting their property out.
It's a must, isn't it? It's a must.
It's a no-brainer. You need to have that guarantee.
So Neil said in the chat, Paul, currently over 12 months in London to get possession at the moment anyway. So Lord knows what that's going to
can you imagine what that's going to be?
Yeah.
The bill comes in. I don't understand it. I've written to all 4 MPs and said, look, I just need to try and understand why has it been set at 3 months. And the response is that they seem to think it's temporary arrears, and that's how it's worded. The tenant's going to fall temporarily into arrears by 3 months, and that they assume that once they hit that, they will then pay it back. I think we all know, everybody knows, that once you hit 14 or 21 days rent arrears, that's a bad debt.
You've got a bad debt.
You're not coming back from that. And you're going to have to follow the process to get that tenant out. For whatever reason, they're falling into those arrears. They can't escape them. It's a bad debt.
Yeah. So Hayley's asked Paul, which is probably on the landlord side, is there any provision to improve rental recovery from that? Is there anything that's being put in place, or is it kind of you've got your deposit, that is it?
So rental recovery in terms of possession, recovering the rent.
Recovering from, Hayley, if I'm getting the wrong end of the stick, but a tenant not paying rent, you want to get it from them. Are they making any provisions to improve that?
No. In a nutshell, no. It's exactly the same as it was. So there's various different ways in which you can, once you have the money judgment, you can enforce the money judgment in various different ways. But there's, as far as I'm aware, there's nothing additional added to that. But the simple fact is, if a tenant isn't paying the rent, chances are the tenant doesn't have the rent to pay, unless they're a professional debtor. Which means that's fine. Yes, you have a money judgment, but now you have to pay to enforce that money judgment. The chances are you're going to get £2 a week for like 25 years. Utterly pointless.
Yeah.
So the idea is to try and stop them falling into arrears in the first instance. And that I think you're going to see lots of insurance companies doing something like a payoff, and that might become the new default model where you would offer a sum of money, or the insurance company would offer a sum of money to the tenant to vacate the property. So it might say, right, we'll pay you 2 months rent for you to vacate now and drop the keys off.
Yeah.
Because it's going to be quicker to do it that way rather than to go through the courts.
Go down that road. Absolutely. Paul, I couldn't help but notice on here, it's not really our as a business area of expertise, but that ground 4 on the mandatory grounds, the student accommodation, has that been added in? Because I know there was a little bit of kind of concern about how the student accommodation was going to going to be put in there. But in the 12 months prior to start of the tenant's property was let to students can only
I think there's still a lot of talk about student accommodation because it doesn't fit the normal residential model.
That is used by specific education establishments. So there's a lot in there in terms of student HMOs and lets, which I know that there's a lot of concern in the market on that. So I know there's people fighting on that out there. And then you've got discretionary grounds as well, Paul. So don't know whether you wanted to touch on those.
The discretionary grounds you'll see, and the discretionary grounds notice periods are far less because these are tenant fault grounds. The issue with discretionary grounds is that fine, you can prepare your pack, you can get it ready, you can go to court, only for the judge to go, well, actually, no, I don't agree with you.
Yeah.
I'll either going to adjourn this way, I'll secure more information, or actually say, no, I'm going to throw it out of court completely. So there is an element of risk on going under a discretionary ground. So with rent arrears, for instance, we always issue under grounds 8, 10 and 11. And we do that because if the tenant falls below the current 2 months rent threshold when we get to court, we can rely on grounds 10 and 11, which basically consistently in arrears. And sort of not making regular rent payments, and that always works for us. But I wouldn't necessarily advise using a discretionary ground only because, well, there's no guarantee that you will get possession and you're having that expenditure of getting yourself to court.
Absolutely. Paul, there was quite an interesting, I did a little poll then, and 71% of the landlords today on here have not had to use a Section 21 to get a tenant out.
No, and this is it. Apparently, Shelter says, it was the other day, they said landlords are marching tenants out of their properties in hundreds and thousands. I honestly don't know where this information is coming from. A landlord has a property, they want to let it out. They want to let it out because they want an income. If the tenant's abiding by the terms of the tenancy agreement and they're paying the rent, why would they want to remove them? It's nonsense. But
ourselves as a firm, I can the reasons why we serve notice is for those items that were in the Section 8. Landlords looking to sell the property, kind of those items are the main reason why. It's not, you don't just serve a tenant notice just for the hell of it very often, do you? Really?
No.
So talk to us, Paul, a little bit more about kind of strengthening those tenants' rights. Obviously there's a little bit about being able to challenge rent increases, end the bidding wars, as well as a couple of things. So maybe talk a little bit more about, I think the bidding wars is probably a quicker one that you can whip through just. I can
rattle that quickly. So basically at the moment, you market your property, say £1,100, and you get a load of applicants flock towards the property and say, we all want it. And then someone says, look, I'll give you 1,200 quid because I'm desperate to move in with my family, etc. The landlord has the right now to go, okay, yeah, fine, fair enough. I'll take that tenant, etc., etc. That will be banned. So basically, if you market the property at £1,100, you can only let it for £1,100. You can't accept or incite any form of additional bidding. It has to be the £1,100, and that's it. So all that's going to happen now is that you really have to give considerable thought to where you position your property when you market it, because that will be the price. And that's it on that one. In terms of rights for rent reviews, now, as we know, Section 13, that's the current document that we use at the moment for increasing periodic rent, or rent on a periodic tenancy agreement, should I say. It's a 1 month notice, and that will increase to 2 months. But the issue we got now is that the tenants currently have the right to refer it to the tribunal, but when they do, the tribunal can look at it and they can decide to go up or down. So say, for instance, you had a £1,100 rent, and I wanted to increase that to £1,250, but actually the market rent was £1,500. If the tenant were to refer it, the tribunal could vote in my favour and say, well, actually, no, you're not paying market rent. We're saying it's now £1,500, and the tenant has to pay the requested increase from the expiry of the notice. That's all changing. So what will happen is the Section 13 notice will be issued, and the tribunal, the tenant can refer it, but the tribunal can only agree up to the level that you have suggested. Yeah, so, you know, long gone are the days where landlords are going to be friendly to tenants and say, look, I'll only put up a little bit. They need to protect themselves and say, right, I need to put it up to the market rent because chances are it's going to be voted below. This is one of the things. So chatting to the tribunal service, they do roughly, I think someone said about 900 applications a year. All right. They will be doing, it is expected, in excess of 1 million applications a year. And currently there is no additional funding planned for the tribunal service. So you can imagine how long it's going to take. I've issued you your notice, your 2-month notice. You have referred it to the tribunal service. Now I sit and I wait for the tribunal service to get round to it and sort that out. And there's no additional rent coming in until such time that they sort that out as well, which is just utterly ridiculous. And there's going to be lots of evidence base as well. So you can't just say, well, the market rent's this. You have to evidence it to prove that that's what the market rent is. But the problem that you've got, so you and I both know, Phil, if I reviewed your rent now, if that got in front of the tribunal service in 9 months' time,
it will have gone up.
The rent will be different. But my evidence would be based on now. And they will only increase it to what I've asked. They won't increase it to what the current market rent is. So landlords are always going to be on the back foot. So it's really, really important that their pensions pay attention to what their rent is and future plan to make sure that they are covering all of their expenditure, thinking of the worst case scenario.
It's also worth saying, I think Sally's also mentioned it in the chat, it is important to get an understanding tenant. It's going to be down to us guys even more to make sure that we put the right tenant into that property and not someone that's going to go in and then start moaning about X, Y, and Z. That is your pivotal report, because of if you put someone in that isn't right, you're gonna be stuck unless they do something wrong. You're kind of stuck with that person for an extended period of time, aren't you, Paul? Really?
Yeah, it's going to be like the old rent-take tenancies, pre-housing tenancies. Yeah, you're going to be stuck. So it's in the past, landlords may have done favours for tenants and said, okay, we'll keep the rent low at this particular period, increase it there. But now it's very much business driven, isn't it? You've got to look after yourself because there's going to be so much red tape and you just can't make quick decisions. You've got to look after yourself first now before the tenants. And that's horrible, because this bill will actually degrade the relationship that landlord and tenants have. It's not going to improve it, but there you go.
There you go. Any other items in there, Paul? I'm sure there's a massive list, but is there anything burning, kind of strengthening the tenants' right? I don't know. One thing, actually, I might not have heard you saying, but when they take the rent review to tribunal, you don't get paid that extra rent, whereas you do at the moment. So it carries on at the rent that it was before until the tribunal date, which could be 12 months further, and then they start paying the extra amount. I don't know whether you said that, Paul, but that was just something.
It's Section 13 at the moment. You have to start paying upon expiry of the notice. The new one is you don't pay until it's adjudicated by the first tier tribunal.
Absolutely. Well done. Anything else to?
The only other thing is, I don't know if we can a little bit later, is advance rent. Now, at the minute, we can, a landlord might have an application from someone who hasn't got a particularly good credit profile, but has the income. So they might take a risk in them and say, okay, well, if you can pay the first 3 months rent in advance, just as something to make me feel a little bit happier. That happens a lot. That will be unlawful. That will be banned. You can't charge or receive more than 1 month's rent. To do so will be unlawful and will carry a £7,000 fine.
Super stuff. Sorry, Paul.
No, you're right. I can see you're busy. I can see them all coming in. I can see reading. So bring up the next slide.
Yeah, I'll get that one there. Then I can. This is probably a hotter topic than it should be in some respects, isn't it, Paul? But I think it's yeah. Go on.
Yeah, I'm going to keep. We can come back to other questions afterwards. We're going to now talk about pets in lets. So there's been a lot of talk about this, and I think that there's been a lot of focus on you have to give your tenant the right to have a pet, and there's an element of that's true. Yes. So the tenant, you can market the property. You don't have to market the property as available with pets, but once a tenant has moved in and they make a request for a pet, you have to consider the request, and you can't just give a defaulted automated no. You have to give a reason within an agreeable time. There is a time frame. I forget what it is now. It might be 21 days, might be 31. I can't remember now. But you have to respond to that in that time and give your reasoning. So if your reasoning is no, I just don't want you to have a pet, then that tenant has the right, or still has the right, regardless of what your reasoning is, to refer that to the first tier tribunal. Now, all of a sudden, the decision-making element is taken away from you and is put with the tribunal, and the tribunal can say, well, actually, yes, we think they can have a pet. So, sorry, Mr. Landlord, they're having a pet. However, the positive side to this is that you can secure protection for yourself. So what they're going to do is they're going to amend the tenant fee ban. Now, we all remember the tenant fee ban in June 2019. Can't charge anything other than rent. They will amend that piece of legislation to say that we can charge the tenant pet insurance. So we all know what we're going to do. If you're my tenant and you say, Paul, can I have a dog? And I go, all right, then go on in. But as long as you get insurance, you'll be like, yeah, of course we will. I'll get that insurance, no problem whatsoever. So
I'll get insurance, Paul.
Yeah. I'll send you the policy and I'll cancel it. That's going to happen. So what the provision is there, a landlord can actually take out a policy and recharge the cost of that policy. It can only be the cost. There can't be any admin fees or anything like that. But they can recharge the cost of that policy to the tenants. And that's an acceptable charge to make. So the landlord has an element of protection there. So if there is something that happens, they can make a claim on the policy. I believe the tenant is also responsible for the excess. So that is a positive.
Can you charge that through the rent pool, or is that a separate one you have to kind of send?
You can make the charge for the rent and the policy, etc.
It's important to note that such grounds are if something, say, if you're in a block of flats and in the head lease it says that you can't have pets in that building. That is a reasonable reason to say no to it. So yeah, it's.
I think see, we've asked for guidance, haven't we, from government? The government said it's too big of a topic to legislate. They can't provide guidance on every eventuality, so they're saying you just need to use common sense. It's like, right, okay, that's useful. So I guess if you're in a flat and you're asking for a budgie, well, is that reasonable? Yeah, probably is.
Great Dane in a flat.
Well, if you wanted 6 Great Danes, then that's beyond the realms of reasonable, and no, you can't have it. I think everyone just needs to be sensible with the replies, but we just have to make sure that we don't just say default no. This is the reason for it, and we reply within the given time frame. That's all.
Yeah. I think there's always going to be a bit of there is going to be a grey area, isn't there, Paul?
Yes.
That we there's always going to be some fun and games associated with it, really, on that front. Decent home standards, which is another layer in. Number 4, private rental homes will now need to be safe and hazard-free, which they already have to be. Landlords who fail to address any hazards can be fined up to $7,000 by local councils and may face prosecutions. And I think that even extends now to $40,000 and criminal.
The easy way to remember this is under the bill, any breach of, when it becomes law, any breach, initial breach, £7,000 fine. Any second or continuous breach, £40,000 fine. All right. And that's just the fines. You then have the issue of the tenants having the ability to claim a rent repayment order. They can do that at the moment, up to 12 months. That's going to double up to 24 months. So you can imagine if you've been slapped with 2 offences, you got a £40,000 fine, and all of a sudden you've got a rent repayment order.
Paul, just to stop you there quickly, just for some that might be watching, what's a repayment order?
Right. Okay. So let's give an example for it. So let's assume that tenant reports a boiler's not working, or there's mold. Actually, let's assume that the tenant reports there's mold in the property, and the landlord does nothing about it. And then the tenant reports it to the local authority. The housing officer goes around and says, "Yes, there's a problem here." They issue a works order to the landlords, and the landlord ignores the works order, and the local authority have to get the work done. They then fine the landlord. What they can then do, and they're going to actively encourage tenants to do this, is then for the tenant to apply for a rent repayment order. And what the tenant can do is the tenant can say, okay, right, so from this point that I reported this to you, all the way through to the point that it was dealt with, say for 6 months, could be, the tenant can claim an element of that rent back from the landlord.
Right.
So the landlord's going to have to pay for a fine, pay for the maintenance, and then pay the tenant's rent back. And they've got 24 months to do this. So say this happened this year, tenants left, and you think, oh, right, well, that's gone, move on. No. That tenant can claim for up to 24 months. They can come and hit you in a year's time, say, well, actually, when I lived there for 6 months of that time, I didn't have this, that, and the other. I'll have 85% of my rent back, please. Thanks very much.
Right.
So yeah, it's a little bit scary.
And that again, Paul, is a reason probably to go back onto our last webinar on the importance of carrying out these routine inspections, isn't it?
Yeah. So it's what the bill is pushing. I think we covered this as well. It's pushing landlords to be more proactive than reactive. It's to proactively manage the property, treat it as a business. Don't just allow the tenants to just stay there, pay the rent, and not go to the property. They're highlighting the importance of becoming a landlord and responsible and professional landlord. Ultimately, you're going to be responsible for the condition of the property. Gone are the days where you say, well, the tenant didn't report it. That's my get out of jail free card. That doesn't wash anymore. You are responsible for highlighting and dealing with issues, even if the tenant doesn't report it. That's the way it's going.
Okay. And in terms of decent home standards, Paul, just a couple of kind of obvious ones.
It shouldn't be too much of an issue for most people. It's nothing to get too scared about. It's currently in social housing at the moment. They're going to extend it to private rented sector. Just give you an idea of some of the things they're looking for. So, for instance, kitchens must be no less than 20 years old with adequate space and layout. Bathrooms no less than 30 years old. Property would need to have adequate noise insulation where required. Must have effective heating systems and proper insulation. They have given you details. So for oil and gas heating, there needs to be cavity wall insulation or 50 millimeters of lost insulation. Electric, that goes to 200 mils. The tenant has to have the ability to warm the house as per the mean temperature dictated in HHSRS, which I think is about between 18 and 21 degrees. So if you're starting to fall back on any of those, and what's really important now, because this law is coming, and the core contents of this law is going to remain the same, landlords really need to start thinking about their properties. And maybe if they've got some aged properties that perhaps need a refurb or something like that, they really need to start planning and thinking about, right, is there anything I need to do now to get ahead of this in a proactive manner, rather than waiting for it to be referred, and then all of a sudden you've got the potential of fines, etc., works orders, bills, etc., rent repayment orders. It's better to be ahead of the curve now and really think about, is my property fit for when this bill drops as legislation?
Super stuff. Nelly, you've asked, will this be retrospective or only applicable to new tenants? I don't know which bit you're talking about there.
Well, the whole bill, I can answer this now.
Oh, okay. Yeah, answer it as the whole bill. Yeah.
The whole bill. So ordinarily what happens is when a housing bill drops and becomes law, it affects new tenancies, and then you have what they call a transitionary period between 6 and 12 months, after which it then affects every single tenancy. They've made it very clear that when this drops, it will affect every single tenancy from day one.
Okay. Old Rent Act tenancies, they'll be outside it, won't they? They're already
Rent Act tenancy. Yeah, this is affect Housing Act tenancies, short hold tenancies.
Right. Let me have a look. on here? Public sector, charity.
We'll get lots of questions.
Any difference between charity and public sector? It's not an area that we
charity tenancies. My understanding is they're still short-hold tenancies. Mm-hmm. So if they're short-hold tenancies, then they're affected.
Probably.
This bill is going to affect the short-holds.
Okay. Number 5. I think you've already you have mentioned.
Yeah, we need to talk about it a little bit, because we talked about this in length in the last webinar, but this is something that landlords need to pay attention to. Mm-hmm. So Arab's law coming in. Obviously, the history of this is Arab Ishaq back in 2020 died from exposure of mold, and that was in social housing. And this is why this law has come out. It is in social housing. They're going to extend it to the private rented sector. And what it does is, at the minute, there is, under Section 11, if say, for instance, a boiler stops working, the landlord has to deal with it in a reasonable amount of time. There isn't really a framework there that dictates how long you have to deal with it and what is reasonable. This is going to change that. This is actually going to create a framework where, once a tenant's reported an issue, a landlord has to do A during this time. A landlord then has to do B during this time, and then C during this time. And if they don't, it's considered a breach. And as with all the other parts of this bill, any breach is a £7,000 fine. So it sets out very quickly what it is the landlord has to do, and the clock is ticking, and the landlord has to keep accurate records. It can't be a case of the tenant rings you and says, the boiler's not working. You go, okay, well, I'm there in a couple of weeks. I'll deal with it then if that's all right. It's not particularly cold outside. That won't wash. You have to show that you've actioned it immediately, and then update the tenants in exactly what it is that you're going to be doing. And then there's a timeline for getting it all sorted out at the end. And that's all very well and good. But if a tenant is reporting mold and condensation, I saw a couple of comments there earlier.
Yeah.
Sometimes it's very difficult to establish the cause of mold. And more often than not, it's lifestyle. And you can provide the heating, you can provide the dehumidifiers, but if they're not turning both of them on, not really huge amount you can do. You can't kick them out because Section 21 won't exist. So it's going to be very, very difficult to try and pinpoint, but the landlord will have to spend that time pinpointing it and basically updating the tenant and saying, look, this is what we're going to be doing.
Yeah, and Andrew Walters, I know the name from being a surveyor in the area for a number of years, and it said it is reality that the majority of mold condensation is due to actions of the occupiers on that front, isn't it, Paul?
Yeah. I see. There's a little note there from Jane. What happens? This is a bit off piece a little bit, but if the landlord dies, what happens to the tenant's rights? Nothing. The tenant's rights remain. The landlord's estate picks up the responsibility of the tenancy.
Absolutely. Just before we move on to the 6th section on here, I am just going to drop in a little bit of a link to subscribe to our YouTube channel, guys. So this is where you can kind of get hot updates in between these webinars. We only run these webinars quarterly, but me and Paul will often jump in and do little updates, like I did a video this week about stamp duty changes, those kind of things. So do subscribe to that, because there's lots of little updates. We try and do at least every week a little video on there. So do subscribe to that, guys, because just to keep in touch throughout and in between the webinars. So Paul, the last kind of section on here is digital database and property ombudsman. The new digital database will provide tenants with information when entering new tenancies. The property ombudsman will provide a fair and resolution service to settle disputes without need for court involvement. Yeah,
so as agents, all agents have to be a member of an ombudsman. That's a legal requirement. So what they're going to do is, so even if you are a managed landlord, you still have to be a member of a ombudsman, and that's there to protect the tenant. So if you don't do something that you're legally or contractually bound to do, the tenant has an avenue to go down to resolve the dispute that you may have with your landlord. The digital database is something very, very different. What they're looking to do is to create, I think they're going to call it a portal, where every landlord has to register on the portal, and they have to register every single property that they own on the portal. It's not entirely clear what level of personal information will be on the portal, because obviously there's GDPR that needs to be considered. But they will have to register it, and they will then get a code for each of the properties, and that code then has to be displayed on any marketing information. So when they let the property or market the property for let, they have to put that code on, so that a prospective tenant can log onto the portal, enter that code, and look at the credibility of that landlord. Has that landlord had any banning orders in the past? Has that landlord breached anything and has been fined or convicted for? And they will be able to see a history of that. And then the idea being is they can make a judgment. Yes, this is a good landlord. No, this is not a good landlord. I won't go to them. But the issue is that the landlord will have to pay to do this, and there will be a registration fee, and then there will be a fee for every property that they register. What that fee is, we don't know, because we've not been told. But
there was also talk, Paul, of a questionnaire in terms of a test that you'd have to do when you register for it. Is that still potentially the case? I know there was some
do that in Wales.
Wind on that. Is that the situation in Wales?
Yeah, in Wales, landlords have to take like a fit and proper test to show that they understand how to be a landlord. But it's a very basic test. If you get the question wrong, it tells you, and you pick another question until you get it right.
And it's a multiple choice one, yeah.
It's not going to take a rocket science to get through that question now. But I'm not aware of there being one in England at the moment. But certainly the portal is, they've made it clear that so agents can't register properties for landlords at the moment. So a landlord will have to do this themselves. If they don't, and they market the property for let, guess what? £7,000 fine. If they do that for more than one property, guess what? £40,000 fine. So that's going to be really, really important. We don't know when the portal is going to open. The last time I spoke to a solicitor, they said basically what will happen is they suspect once the bill gets royal assent, there'll be a period between then and the bill becoming live. It will be that period there. So it is going to be a case of, oh Christ, right, admin time, and everyone's going to log on. The website will probably crash because it's a government website; they're always crashing, just because of the volume of people using it. So yeah, that's a little bit of a worry.
I will just say that obviously, if you are a client of ourselves, then we will certainly take you through the process of that and do most of the donkey work for yourself in whatever way it will happen. It might be that we have to put your personal email address in to get the physical code, but hopefully it will be as simple as you'll be able to get the code and then come through to us with it. But until we know how the system works, we don't know how hands-on everyone's
we will also, there will be guidance issued by government anyway, and we will also break that down with guidance that we will send out to all of our clients to say, look, this is what you need to do, and we'll help them through the process because we need that registered. We don't know if that will be a case of you have to register before you market the property for let, or if you have to register every single property, because obviously it will affect every single property. So if you've got 10 that are already in situ and you're marketing one, do you need to register all 11, or do you just register the one? I don't know. I suspect it will be you have to register all of them.
Something I actually saw come up, I had an email this well, it was today actually, Paul. I just thought I'd note on it. It's not so much more for the landlords, but it's more for us as agents as well, in terms of this, that the regulation of property agents is coming as well. Yes. ROPA, isn't it? I don't know whether you saw it pop up, Paul, but that's something that they're certainly doing, which I think personally for us as a business is great, because of there's a lot of agents out there, and I can see from the attendees, we've actually got agents that are watching this today, learning from ourselves. We've got some ex-members of staff. I've seen some names on there, Paul. But But yeah, I think ROPA is a brilliant thing, that it's going to make sure that we're doing our jobs properly as well, which I think is well overdue. So that's something that's coming in, and our staff are doing all the training anyway.
We've got 95% of our staff already qualified, so
yeah,
it's not an issue for us. But yes, you'd need to have level 3 qualification, directors level 4 qualification in order to practice. So you have to secure your own personal license in order to practice, and that's a renewable license. It's not just issued and forgotten about. It's something you have to keep, and you have to continue to do professional development in order to keep it.
So I think we've touched on obviously the fines, banning orders, and the rent repayment orders, Paul. So unless you've got anything you would like to add to that, I'm going to jump into a little.
Well, I don't really want to read this out, but there's an awful lot. I mean, we've covered like the very top.
Skimmed it.
Oh, we've skimmed this. There is a lot there. I mean, my notes is like 16 pages long, but there is a lot there. And as I say, I think what we agreed that we were going to do is send like a transcript, didn't we, out at the end of this to everybody, just as a copy of the notes that we've got with some information in there. And we will constantly update that. And the best thing to do is, as you said earlier, is to register on our socials. So it's like YouTube, Facebook, Instagram. Get yourself registered, because they will be the first place that will be issuing that information. We'll fire it out onto the socials.
And again, if you do want to have a physical chat with someone, it might not be for a physical tenancy health check. You might feel that you don't need one of those, but do book in there for a slot and talk to us about anything else that might be of a concern for yourself, which is coming in with the bill or anything like that. So do book in for a tenancy health check through that link, and yeah, we'd love to hear from you and have a chat with you on there. But was there anything to add, Paul, before we jump into some of the questions? I think we've got quite a few questions.
No, I think the only thing we this has been a bit doom and gloom, isn't it? But it's not all doom and gloom. So I just want to assure everybody now. Yes, it's a massive change to how we do things. The biggest change for 30 odd years. Yeah. But there's been a lot of change, and we've always got through. This will change things, but we'll get through it. There's more admin, yes, but it's fine. You just need to make sure. I think, whereas before you've had an opportunity, okay, well, I didn't necessarily know that, and I didn't deal with it. It's not a problem. They are going to be so hot on this. You can't drop the ball. You've got to be on it 24/7.
And as a firm, we're here to strive forwards and keep going. We've been here for 58 years, and we're going to push forth and get through this. It's certainly not going to be the end of Boydens or anything like that. We're still here to help, and keen to hear anybody that needs any help on it. Absolutely. But right, let's have. I'm going to start at the top. Okay. Nice to see you. If you do need to go, I understand we've been an hour and 5 minutes somehow already. So we will try and whistle for a few questions, but we probably don't want to keep you all for more than an hour and 15. I think we've all got better things to do than listen to me and Paul for more than an hour and 15 minutes.
They might want to listen to us for more than an hour.
Not sure. Well, yeah, some might. But right, let's go right to the top. So I'd be interested to know how this new bill negates the coaching by the council and shelters to coach tenants facing lawful evictions for non-payment of rent, for example.
Yeah, that will be interesting, because in a minute, obviously, they say they push the tenants to request a Section 21 notice is issued so the tenant can secure social housing. Obviously, that's not going to be something they can do anymore. So yes, you're absolutely right. It will be interesting. I think they'll still do what they say now, is you can't leave your property until such time that you're evicted. Otherwise, you're making yourself voluntarily homeless. So it does put the tenant between a rock and a hard place. It's pretty poo, to be fair.
And then it said, to avoid eviction by underhand tactics. Yeah. Another one from Ashley. Let me see what this is. Had drug dealer and a failure to pay rent last year. Have had a torrid time but Section 21 was the only way to evict due to council coaching. My concerns are Section 8, as it stands, in my experience, not fit for purpose and will cost landlords costs that could break a portfolio holder. I know I've been there. Again, I'd say this is a prime thing of why rent guarantee is a real pinnacle, isn't it, really, Paul? To make sure that you are getting that in place. And there's a lot of rent guarantees on the market, aren't there, Paul?
There are. You can get some literally
compare and all that kind of thing, but they don't cover enough of the items, do they, Paul? I don't know whether you wanted to elaborate a little bit more.
You can have big providers, and the key thing to add here is that a lot of the big providers actually, when COVID hit us, withdrew their product regardless of whether or not you paid it. I'll just hasten to add, we didn't. Ours stayed in place firmly. But you got the big providers; they literally just provide you with a rent guarantee. So you need to appoint a solicitor. You need to go to court. You need to make your claim. You need to sort out the bailiffs, etc., etc. They just pay you the income. The rent guarantee that we provide covers it all. So in terms of being a landlord, it matters not if the tenant falls into arrears. You still get your rental income. You're indemnified against solicitor and court fees. You get your rental income. We sort out the claim for you. You don't have to go to court. We go to court. You just see the rent coming in. It makes no difference to you. And if you start thinking about now the times, I think someone said in London, they're already waiting 12 months. You start thinking about the times it's going to take to get possession. It's ridiculous. But if you've got something that's ticking over the back and just keeps paying you that rent, all of a sudden it takes that burden and that stress away from you. So if anybody wants to talk about rent guarantee, you get in touch. Because I would encourage every landlord, even if you've got a tenant in situ now, you might still be able to get a rent guarantee.
Ian has asked, actually, probably quite rightly so, Paul, and I think there's a certain amount unknown for ourselves. Do you think this will affect rent protection schemes fees, the costs of them? I think that they will probably go up. I would expect, being a business owner, I think that it's got to be.
They're taking on. They need to look at it as a risk. It's going to be. They're going to risk assess, aren't they? So they've set the fee based on 6 months to get possession. Right. Well, if that doubles, then all of a sudden they're going to be paying that more. But as I said earlier, that what they might do is actually adopt different tactics. So I think if the debt is over 5,000, you can go to the High Court Sheriff. But they might adopt a buyback from the tenant and just say, right, we'll give you, the tenant, X amount of money, but when we drop that into your bank account, you need to give us the keys back. So basically avoid the need to wait and just get possession. I think they're going to look at it in a very different way and come up with some rather ingenious ways of securing possession, but still within the law.
So Rhiannon's asked, or Remore has asked, would now be a good time to get all landlords to A, agree to rent guarantee, and B, enforce 6-month break, no pause in all tenancy contracts?
I don't see the benefit of the second one, but certainly the first one, yes, get your rent protected. So if I were a landlord now, the first thing I'll be doing is I'll be going to the property, I'll be doing an assessment of the condition of the property, I'll be assessing the rent. Am I charging the right rent? Because soon I'm going to be restricted in how I increase this rent. You need to sort it out now while the current legislation supports you. And then 3, getting a rent guarantee so that I'm 100% protected. That will be the first thing that I would do tomorrow.
I think Kieran here is having a little bit of a joke on that one. So what you guys are saying is I should quit my job and become a professional squatter to get paid out to move out of a property and do it all again. Well, it could be a career move yourself. I don't know what you do for a career, but yeah, you could kind of
that's one of the things. We didn't touch on this, did we? But everything's going to be a periodic tenancy. There'll be no fixed terms. So the tenant can serve 2 months' notice from day one to vacate the property if they wish. So, I mean, chances are they're not going to, because there's such a lack of decent properties on the market, but they do have that option.
Absolutely. A couple of, I'm going to read these ones out here, but these were raise a question for the Landlord Webinar. Ian and Mark and a few others did put some in prior, so I'm just going to read these out. Paul, an existing tenant's contract expires in February, but they are now looking for a house to buy and don't want to commit for another year's contract. However, they would like to continue to rent the property on a monthly basis until the purchase is completed. Am I leaving myself open to problems if I agree?
No, I would. I mean, it really depends what the landlord wants to do. If the landlord wants to continue renting the property, I think if you ordinarily, if the bill wasn't becoming law, forget the renters' rights bill, if that wasn't there and someone presented with that, I'd say, right, okay, well, if you were uncertain, you wanted fixed term tenancy, then you might say, right, we'll issue a section 21 and then relet that property for another 12 months. So you've got security of tenure for those 12 months. But that would be completely pointless, because when the bill comes law, everything goes to a periodic tenancy anyway. So it makes a difference. So no, you're not leaving yourself open. You've still got the protection. So as long as they're good tenants, I would allow it to happen.
I think in a way, and I think you could almost do a bit of negotiation on it, in terms of, you could say, well, I'd ideally like you to sign up for 12 months, but because you're going on a rolling tenancy, I'd like to serve a section 13 and increase the rent to X amount. Because of that method, it might be a bit of a negotiation tactic there. I don't know whether you agree, Paul, but that's what I'd probably go down on that route. Anything else to add on that one, Paul? Mark has asked, good afternoon, please can you advise what the landlord's duties are regarding electric checks and certificates? How often are the tests due, and should certificates be given to tenants in the same way gas certificates are? So I think split this into two, Paul. Split this into kind of EICRs, and then probably do your fire alarms and your carbon monoxide and those kind of things, because they're two kind of different electric kind of things, aren't they, I suppose?
Yeah, so your electrical installation condition report has a 5-year term. So yes, you're legally obliged to get that completed. You have to have that pass certificate to the tenant within 30 days of the start of the tenancy agreement. In theory, you're supposed to lodge a failed certificate at the local authority, but they'll probably send it back to you, so don't have anybody there to look after it. But yes, you don't have to serve that on the tenant in the same way you do a gas safety, because it doesn't form part of the Deregulation Act. Gas safeties have to be served on the tenant prior to the tenancy commencing. That's the difference. Electrical installation condition report, you can give that to the tenant within 30 days of the tenancy starting. It doesn't have to be at the beginning. At the moment, if you don't serve the gas safety correctly, you're in breach of the Dereg Act, which will actually become a problem when you try to seek possession. Now, my understanding is obviously the Dereg Act won't exist when the Renters' Right Bill comes in, but there is talk that if it doesn't mean that you won't be able to, it doesn't mean that you shouldn't serve the gas safety in the same way, because I'd imagine that will probably become an issue in terms of trying to secure possession.
Super stuff.
Does that make sense?
Yeah.
Cool.
I think so. Just getting wary of the time now, so we're just going to briefly go through. Can you tell me what happens for a probate repossession, death of a landlord? That would be you'll be able to. You can serve a with the bill, if it's coming in, you can serve a Section 8 for selling a property, so that is fine. Therefore, landlords just ask for a higher rent to start with. That's about the bidding wars. Potentially, it depends where in the country you are. I know, speaking to some agents last month, a lot of people, it actually goes above market rent everywhere. Where we are, I must admit, we don't often go above market rent, do we, Paul? It's kind of, it goes up at that price, and it's kind of agreed that in a few cases it goes above the asking kind of rent.
The landlord has options. those options will go.
Mm.
So I'd imagine, I mean, certainly if I were a landlord, I'd be thinking about, right, okay, I need to make sure the rent I set is going to be sufficient for me as a landlord for the next 12 months at least.
Mm-hmm. Michael's asked, I've moved out to a rented property as my family gets bigger due to my own property being 2-bedroom. I want to repossess the property to sell in order to get more money to buy a property. What do I do, please? At the moment, you can just serve a Section 21. So at the moment, you can do anything as normal, as long as you've obviously jumped through the hoops and done everything properly whilst managing that property. The bill isn't in place. We're talking about next, when are we thinking? August?
No, probably July. June, July next year. So everything in a minute stays the same. So if you wanted to sell it, my advice would be get on it now. Don't leave it. Otherwise, come say if the bill drops on the 31st of July, come the 1st of August, you can't serve notice on tenant for the first 12 months.
Interesting one here. Jacqueline asked reference to pets, lets in pets, or pets and lets.
Pets and lets.
Can I get insurance for a pet already there, respectively? Yes. You can do that at the moment now. So stuff.
I'd imagine there'll be once this becomes law. I imagine there'll be lots of insurance companies offering this bespoke service to landlords and tenants.
If your property has no garden fences, would this count as a reasonable no for pets? No. I probably question why the garden hasn't got fences anyway.
I wouldn't.
No. If it's down to the tenant's lifestyle and you install vents and dehumidifier, does this constitute as taking action? That's Arab's law.
There is a grounds for deterioration of property. I believe that is a discretionary ground. So yes, you can take action against a tenant if you can evidence that the manner in which a tenant has lived is deteriorating and degrading the condition of the property.
I think, Paul, it's meant in terms of the question as does that suffice you from being kind of billed and charged and potentially getting a £7,000 fine, that kind of thing?
So don't know, because they're looking at how do you 100% guarantee that the tenant is at fault. I think what the local authorities will be looking for you to do is to do everything that you can. So putting in more, carrying out surveys, having the mould removed, because they will look. So even if the mould is there and it is found out, yes, it's a tenant responsibility, they will be looking for you to remove the mould, to reinstate the property to a fit standard so the tenant can live there.
Could be a good time to start a business for
damp surveys.
Yeah, damp surveys, couldn't it?
We're gonna branch out.
But yeah, anyway, I don't know what Kelvin's. How about fixed term and rolling contracts?
There will be no fixed term. Everything's rolling when the bill drops. Yeah.
Protect tenants who have been evicted because the landlord wants to sell the property. The tenant decides to leave before the tenant and the landlord refuses. That's a quirky one. Kelvin has. Does the new rental law protect tenants who have been evicted because the landlord wants to sell the property, but the tenant decides to leave before the 2-month notice period and the landlord refuses? Does the law offer any support to the tenants in this situation? How long has the tenant's notice period changed under the new law, Paul?
Yeah. So on a periodic tenancy at the moment, the tenant's only required to give the landlord 1 month's notice. That will change to 2 months' notice. So the tenant's required to give you 2 months' notice. Now, if it's agreeable with both parties that the tenant only gives 1 month's notice, that's fine. But if the landlord is found to be responsible for coercing a tenant out of the property earlier than the 2 months' notice, £7,000 fine.
So this comment here is that the tenant wants to leave early, but the landlord doesn't let them.
No, landlord doesn't. You can hold them to the 2 months.
Yeah.
They will be responsible for a 2 months notice period to end on the tenancy start date.
Michael has asked again on that front. What do you mean by rolling contract? Is it?
Oh, sorry, Michael. That's a statutory contractual periodic tenancy. So that basically means that the fixed term, rather than fixing your tenancy for 12 months, it's fixed for a monthly period only, and it literally rolls from month to month to month.
Super stuff. But yeah, any questions or queries on any items? I know I've got some further questions here that we will get back to, because they were kind of in paper format. We'll come back to you guys on those, but I'm bearing in mind that we've got over 80 people here. We kind of started with 110, 120. So yeah, I'm going to let you all go for your evenings. And yeah, it's been great fun having you here.
Ooh.
Thanks for being so interactive.
I'll put my email on there, but I've actually spelled Boydens wrong, so I'm trying to type with my keyboard up really high. But that's my email address. If you have any questions on the renters' rights bill, then by all means, drop me an email, and I'll get back to you as soon as I possibly can. Just spell Boydens correctly, unlike I did.
Where have you put it, Paul? Because I can't see it.
Oh, I'll put it in the Q&A. Hang on 2 seconds. I can get to type it right now.
I'll chuck mine in as well, and then if anyone has any more questions, kind of sales related, rather than your guru on the on that side, then do give us a shout, and we'd love to hear from you guys. But thanks for being so interactive. It's been a great evening. Wishing you all a really good Christmas, Happy New Year. And what is it? November, December, January, February. So it'll probably be end of Feb-ish, won't it? Probably, Paul.
We should have a lot more. I mean, if anything else drops between, obviously they have to report by today. So we might have something over the next couple of days, a bit more information on the bill. If there is, as I say, get yourself registered onto the socials, because that's where the updates will be going.
Yeah, I'll just drop that that YouTube part, because yeah, any update, we'll probably have an update on there pre-Christmas. So we'll probably sit down, and me and Paul have a bit of an open chat, and we'll post it on there. And yeah, we'll look forward to hearing from you lovely people as and when. All right, nice one. Well done, Paul.
Have a good evening,
everyone. Cheers. Bye.
Bye.